Today, our topic is estate planning, where Rick, the probate killer, is going to share some things that we should be aware of. I mean, the last time I checked, Rick, there was a 100% death rate in this country. So it's something that eventually will impact us and our families. And I don't mean to make light of it, but it's just a topic that we need to talk about. Can you just tell me a little bit about what inspired you to go into estate planning? Tell me a little bit about your background.
Yes, absolutely. First and foremost, Rhonda, thank you so much for having me. I'm grateful that you're giving me this platform to speak a little bit. Uh, you know, I got to take you back to the 90s, and what inspired me is just what happened to my family, and we started experiencing death for the first time, back then. And all my family were self-employed. They own homes and they're just in probate, like rapid fire, it seemed like. We're always in probate. And then the last two probates of the four in the 90s, I had to be directly involved with and kind of learned a lot through the process and learned that it's a process that can completely be avoided. And
Rick, tell me a little bit about your experience. I remember you telling me that you worked for a bank, professional experience.
Yeah, so my background, I spent 27 years in the banking industry. I was an executive vice president. I was just seeing families left and right ended up in probate, and what was happening to my family was very current at the time, and it could be something as simple as beneficiaries on accounts. I was protecting assets and building trust with clients, and that's what propelled me because no one else was doing what I was doing. Basically, probate's, and I'll talk a little bit deeper about my story, but probate's the process of which a court is going to decide how your assets are divided. It's designed to prevent fraud, and when you don't specify how you want your assets divided and who they go to, we're talking about assets transferring after death occurs, then the courts are going to decide it. It's going to go through a probate process, and that's really dictated by your professionals. And when I say professionals, if we're selling real property on behalf of a decedent, that's going to be a title and escrow company. They're going to determine whether it's got to go through a probate or not. If it's a bank or an investment firm or a company that's holding retirements, they're going to decide. So we need to make sure assets are positioned properly. And it comes down to the vesting, the ownership of the asset itself. And for my family, we own dry cleaning businesses. And I was born into the business, and we're going through the 60s, 70s, 80s, early 90s. And, I came out of high school, went into the family business, didn't go directly to college. We ended up getting that taken care of and getting a couple degrees, but we just went direct to the family business, and then death started happening and what have you. And my family's in probate for an aunt and an uncle who was murdered in one of our businesses. And then, we lost the majority of our businesses through the Rodney King riots, the LA riots from the fallout of the Rodney King verdict. And we didn't have the money in the capital to rebuild. So my father went and took a hard money loan out on our family home, and then he dropped dead of a heart attack. And we couldn't
Ah,
find the money.
okay.
Yeah, we couldn't find the money, couldn't figure out anything. And long story short, I had to get involved, and there was a probate court involved. There was other courts involved because he had this loan, and there was liens on the property. And long story short, we lost the property. We sued and won a judgment of a couple 100,000, 250,000, I think. But what do you think the lender did? They dissolved that LLC. So we have a judgment against an LLC that no longer exists, and they reopened under another LLC. So that was
Mm,
also kind of my first snapshot of how to kind of manipulate the system and avoid liability.
hmm.
But in any event, I don't think she really knew what was at stake when she signed loan paperwork and took her name off title also. Uh, I think she was just trying to help. I think the family was scrambling at that time, and the only thing my dad had access to get cash was going to be the house that we grew up in and the
Mm,
equity in that house.
mm.
But cash business that shows no income, self-employed cash business that took the benefits of Uncle Sam. The only way you were going to get a loan was going to be some type of asset loan or hard money loan because they couldn't qualify for anything traditional. So
How old was your
when that
dad when
happened,
he passed away?
here's the irony. It was a month before he turned 50. He was 49 years old. There's more to just a trust. I mean, we got other documents that protect against incapacitation, right? Power of attorneys, medical directives, stuff of that nature. And quite frankly, anybody who's 18 or over should have all those documents because you just never know when something bad can happen. But
Mhm.
no, if you have assets, and for me, the rule of thumb really is if you own a home, you need a trust. If you don't own a home, you may need a trust, but you probably won't need a trust. And there's other avenues we can go to make sure
Okay.
your assets transfer properly.
Can you start with the difference between a will and a trust?
When you say will, we're talking last will and testament. Last will and testament is not a transferable document. What I mean by that is you can't transfer assets to a last will and testament. And don't get confused. Attorneys love to confuse. Just because an asset is mentioned in a trust document or any document for that matter does not mean that the asset is held in trust or what have you. It just means it's mentioned. And a lot of people get confused with that. They leave the lawyer's office thinking, yeah, we're good. All our assets are in our trust because they're named. No, we got to do some transferring of assets. That's where a trust comes in. A trust is a transfer of assets. A trust is going to be very specific in naming who's authorized to act on your behalf in death. That's your executor to your estate, your successor trustee, if you will. And by transferring a property or any other asset into the trust, it's then governed by the trust, which allows the professionals like the title company to know who they're dealing with after you pass away. A last will and testament, I'm on record, I'll go on record again, is the most useless document in estate planning. It doesn't do anything. It's recognized in one place and one place only, and it's a place we want to avoid, and that's probate court. It's not recognized through a title and escrow company. It's not recognized at a bank. It's not recognized at an investment firm like your Fidelities, your Edward Jones, Schwab's. It's not recognized in any of those places where a trust is.
I think that is probably the most important thing that you could have said today because I used to think, my dad actually passed away without a will, and so I'm familiar with. Luckily, he had put my stepmom's name on all of his assets, all of his accounts. But I actually know someone else who passed away, and his wife was locked out because she was not on all of those accounts and she ended up going to probate. So imagine you're living in a house and now you can't pay the mortgage. You can't access the account because your name is not on it. So anyway, I appreciate it because I used to think, oh, well, as long as my dad does a will, he never did a will. But then as I, got older and, cared about these things, I learned about the trust. So I want to ask you a quick question. I've got some people, when they close on their house, they're asked at closing, at signing, how do you want to take title? And sometimes it's like, a joint tenancy, maybe it's a married couple, maybe it's a civil union. Um, I cannot advise them. I can tell them you can ask an attorney. What would you say to educate them on the differences between the options they have at closing?
There are times where a real estate agent or somebody in their corner might suggest getting a trust done before the close of property. And we do that quite often. Process allows the title company to title direct to trust and eliminates an additional deed recording. And it stays in as an insured transaction versus an uninsured deed. You can always transfer title after the close of the sale of a property. Say if you're a married couple, you should close as a married couple. If it's going to be sole and separate property, you should close as sole and separate property. A lot of times, lenders and sometimes realtors, they might persuade you one way or the other because of qualifying. And right at the
Mm.
end of the day, they just want to get somebody in a house. They just want to close a deal. So they might persuade a husband and wife situation, and the husband's the breadwinner, and it's going to affect rate. So we're going to go ahead and just buy this home in your name alone and get this loan closed because you're going to get a better rate. It's going to be more affordable. And then nobody advises past that. Now, what about this poor woman who's
Mhm.
not put back on the deed to a home that she's going to call her home?
So after what you're saying is if that were the case that, they closed just in the husband's name, you're saying after closing, they can open a trust, put that home in the trust and make sure that that wife is on that trust. I've had other clients, for the most part, go and open a trust after they purchase a home, and then they might have an existing trust, and then they'll add the home to that trust after closing. So they had to pay, I think, $200 or $300 to add that home to the trust. But what would you recommend, some of the options that they're going to get about how to take title? So they're both sitting there, they're both on the loan. Sometimes it's joint tenancy with rights of survivorship. Sometimes it's, other ways to take title. What would you recommend?
I'm always going to recommend when there is a home involved, real property, that it goes into a trust. The timing becomes of question. Does it have to happen before close or after close? And the answer is either or.
I have a closing on Monday and it's
Mhm.
Wednesday. So it's getting a little too late probably to go and get a trust. But how
Right.
would you have them take title?
If they're both on the loan, they should both be on title as joint tenants with rights of survivorship. But in the state of Nevada, if it just says joint tenants and doesn't have that additional language with rights of survivorship, it defaults to that anyway in the state of Nevada from a
Oh,
title
okay, okay.
perspective. But I like to be very specific. If I'm going to write a deed, it's going to say it's a joint tenant. It's going to say with rights of survivorship. So that way they're protected. They're only not protected if they die together, but at
Okay.
least they're protected if one goes over the other. My business is to try to help families stay out of the courts.
Can't they just go on LegalZoom and do it themselves? Tell me the risks of I'm going to do my own trust and will myself.
I would say that if you feel comfortable, go for it. But you got to understand, I've watched families after families and end up in probate court with these documents done by attorneys. I think having a professional advocating for you and being a second set of eyes is the way to go. You obviously want somebody experienced. It doesn't necessarily have to be an attorney. It's got to be somebody more than just a document preparer. Also, you got to have some experience with these documents, and that's really up to you as the consumer to ask the right questions when you're determining credentials and who you want to go with.
What life events would trigger an update? Like, let's pretend I have, a trust because we bought a townhouse and we have a trust.
So obviously death's one, right? But there's a few, obviously when you amend a trust, you're typically amending two areas. One would be the successor trustee position, maybe a successor trustee predeceased, maybe they found themselves into an incapacitated state, or they just fell out of favor with you as a person who you want in charge of your estate. So you might amend that and change who's in charge there. The other area in a trust you would amend would be your division of assets, and that can that's your beneficiaries. Maybe beneficiaries change, assets change, how you want them divided could change. There's three levels of estate planning, in my opinion. One is where we got young children and we have some assets and we need to prepare for a untimely and unexpected death, a premature death, if you will, and make sure that we spell out how our assets are to be used in support of our children who are going to be raised now by somebody else if tragedy struck us. The next level is, our kids are kind of grown. We kind of know how they've turned out and they can take on some of these roles themselves, or they're not really ready yet because money management issues. It could be drug addiction issues, all kinds of different things. And then the third level is another life changing to answer, which is the last one is now do we have to start looking about Medicaid recovery? Do we got to start looking at we're in a revocable trust. It might be time to move into an irrevocable trust so we can move these assets out of our name because we did not plan for long-term health care. And there's a good chance we're going to have to go into a assisted living facility as we advance in age, and we don't want all our money and the equity in our home being exhausted for that. But there's a lot that's a moving parts there because qualifying, right? Will they even qualify if they're on very low income and have a lot of equity in the house? In fact, I'm doing one right now. We go irrevocable because we want to protect against Medicaid recovery.
And let me ask you a quick question. Do you only do Nevada or do you help with estate planning in other states?
I do other states. I've worked in 35 states. I can prepare the documents, and my software allows me to be state specific in the documents. Um, I can't record the deed in those states. So here in Nevada, uh, Clark County, I should say, and Nye County, because I have an office in Pahrump, I record the deed. I take that off the client's plate and get the deed recorded so I know the house is taken care of at least. And then we advise and consult on the other assets. But if it's another state, it's challenging to record the deed. So that has to go back on the family to get the deed recorded. I do try to help, and it just comes down. Some counties are wonderful. You can call them; they'll tell you exactly what you need to do. You file it. Other counties, not so much. So I usually will preface an out-of-state client by letting them know that, and I'll prepare the documents, but they've got to kind of get somebody in that town or get out there themselves and record.
I want to switch to the topic of celebrities because I think these stories can hit home because everyone has heard about celebrities dying without a will and trust.
The thing you have to understand about celebrities is you got a lot of wealth there. They most of them have attorneys on retainer, and these attorneys are just making money. So I can name two. I can name a local celebrity here, and I can name one that everyone's going to know. The first one's going to be Prince.
Mm-hmm.
Prince died without a will. And
Mm-hmm.
Prince had children that were estranged. I mean, he had children from women all over the place, and now they're all fighting over his estate. But when you think about a guy like that and a musical catalog such as his, kind of like Elvis Presley, although I think he died with trust, but these are the estates that are going to keep on giving forever. You're like born into wealth if you're born into these families.
Mhm.
And then on a more local level, I don't remember what company he owned. I think it was Zappos.com. Tony Shea was
Oh,
his
yes,
name.
yes.
He was a local he was a local guy out here that I want to say it was Zappos.com. I don't know exactly what it, but he became very
Yes,
wealthy.
yes, it
He
was
was an
that
influencer and
one.
yeah, and I think he was God on vacation in North Carolina, South Carolina, somewhere out there in the southeast area, and ended up in a house fire. Just a total tragic and unfortunate, unexpected event for a really young individual who had a lot of assets, but he also died without a will, and that ended up in litigation and stuff. So here's what I say to anybody who owns a business: if you own a business, LLC, corporation, partnership, whatever it is, what we don't think about is how is my legacy that I'm creating in business going to transfer to my loved ones, right? You got your personal assets, you got your business, and the single member LLC, where you're just the sole member of your LLC, is not the best move because if you die and you have a bunch of assets in that LLC, you're in a probate position. So we want to do business trusts. Maybe we specify that in a very well written operating agreement. Um, but a lot of times that's missed in business for sure, since we're talking about celebrities in business, because all these celebrities did own businesses, right? They ran
Mhm,
everything through
mhm.
businesses because of the tax breaks and what have you that they can get and how they can, make
And,
their money go further.
and that's a really good point. How disappointing that these celebrities had attorneys on retainer and these attorneys didn't push for them to have a trust created. You know what I mean? Because I guess that meant more
Well,
money for them in the long term because you're talking about probate court.
yeah, I mean, 100%. Attorneys get paid to litigate. That's where they make their real money through litigation. Lose your loved one, you find out that they had a trust, you find out that you're the beneficiary of the trust, you're the successor trustee of the trust, but then you also find out that the house was never put in the trust or the house somewhere along the way, subsequent to the trust being created, was taken out of the trust. And now you're in a probate position. And what does one do? They call the number on the binder, or the attorney that did it. And then they refinanced in 2020 and they got taken out of their trust and nobody put them back. Well, that's not the attorney's fault, right? My business model is to keep people out of probate. So I have very specific controls in place to help families protect against assets being taken out of the trust. I'm
Right.
not going to benefit from a probate.
So okay, what it sounds like is there's an opportunity for my clients to, number one, either get a trust created or number two, have their trust reviewed. These are services that you can offer them. And when like just to sort of wrap up here, when somebody needs a trust is number one, when they have a lot of wealth. Number two, if they own property, and number three, if they own a business. Did I kind of summarize those? Is there anything I'm missing where they would absolutely need a trust?
No, I think those are your top three. I mean, we can get into more specified products. Special needs trust is going to apply to a family who's raising special needs children, if you will. But that's more of a specialized,
Do
type
you
of
do
trust that
those? Do you actually do those?
I do.
Okay, okay.
I
No,
do.
that's fantastic. So if a client has, a disabled a child or adult, you can help them navigate that sort of long-term planning. I also think about the fact that you need a power of attorney that is going to be able to authorize either healthcare decisions if you're incapacitated, or you're able to authorize financial transactions, right? That power of attorney. And I will tell you, I remember my dad would not sign a power of attorney because he didn't want to lose his independence. So my stepmom couldn't even take off of work and get the FMLA because he refused to sign because he just didn't want to lose his independence. And I understand that. That was old school. I'm sure you can help people do powers of attorney, also known as POAs.
That's part of the whole estate plan is you get your powers of attorney. So when we talk about trust, we're talking about what happens after death occurs. When we talk about power of attorneys, whether it's financial, medical, we're talking about incapacitation. It could be a bad accident. It could be an illness that came on. It could just be advanced age or cognitive ability starting to decline. I'm an advocate for getting those. Is everybody, as soon as they turn 18, should have those. A lot of people don't do that because if you got children away at college, at 18, 19 years old, and God forbid something happens to them, you need these power of attorneys in place, or you're going to find out the hard way. I mean, imagine having to go get a conservatorship over your own child or something like that. And then the other aspect is if you don't get them that young, and I get most don't and won't, you can't wait too long because these professionals, if you will, they're going to question, right? Just because you can get a document signed and a notary out there to kind of notarize it, makes it doesn't mean it's going to be valid and accepted. And I'll give you an example because it kind of ties in, and this just happened last year. This husband and wife, they're in their 80s. The spouse is in an assisted living. The husband's healthy as can be. House is free and clear, owned. Well, he needs money to pay for her assisted living, and he's taking a reverse mortgage out on the house. But she's in her 80s, and in April or May of last year, she signed the document. They present the power of attorney. He's going to handle everything. Well, everything's great, but the lender, because it becomes a risk given her age and they need to protect themselves, they want to see that she was cognitive. So they asked for a doctor's note. Can you get us a doctor's note saying that her cognitive ability existed and she was able to enter into this legal contract, if you will, this power of attorney when she appoints you? So now we have someone who's got a diagnosis that affects her cognitive ability and memory, who's entered into a contract, and the doctor won't sign off on that. Therefore, that loan couldn't go through because the lender needed to see something. To get this loan through, he had to get a conservatorship over his own wife, and the least expensive he could find was $4,000 to do that.
Okay, so if she would have had it earlier, that could have been avoided. That $4,000 could have been avoided.
Absolutely, absolutely. But that just goes to show you, just because you got a notary out there to watch you sign a document and they stamp it, doesn't mean that it's going to be accepted. And I protect against that stuff because I focus more my business on the documents. Or the documents, we'll get them right. I focus more of my business on, what are the professionals going to be willing to accept?
I appreciate you are being proactive as the probate killer and not being reactive when someone's already in trouble. So, Rick, this has been so informative. I really appreciate your insight and your examples, and I'm going to make sure that I share this video, this podcast with my clients. I thank you so much for joining me today.
Thank you so much for having me, and I really appreciate it. The more people that can bring awareness to what I do, the better we are.